The Law of Tort. Occupiers Liability Part 1. The Occupiers Liability Act 1957. Occupiers liability generally refers to the duty owed by landowners to those who come onto their land. The duty imposed on landowners can extend beyond simple land ownership, hence the term occupier rather than owner. Occupiers liability is a distinct form of negligence. It has a statutory duty of care and breach of duty. The common law rules of causation and remoteness of damage apply. The law relating to occupiers liability originated in common law, but is now contained in two major pieces of legislation. Firstly, the Occupiers Liability Act 1957. This imposes an obligation on occupiers with regard to lawful visitors. Secondly, the Occupiers Liability Act 1984, which imposes liability on occupiers with regard to persons other than his visitors. Different levels of protection are expected under the two pieces of legislation, with a higher level of protection afforded to lawful visitors. This video will examine liability under the 57 Act. Both acts impose an obligation on occupiers. The question of whether a particular person is an occupier is a question of fact and depends on the degree of control exercised. The case of Wheat v. Lakin established the test of occupational control. It also held that there may be more than one occupier of the same premises. Physical occupation is not a requirement, as seen in Harris v. Birkenhead, where a 4-year-old child fell out of an upstairs window of a derelict house owned by the council. By virtue of Section 1(3)(a), the Act applies not only to land and buildings but also extends to fixed and movable structures, including any vessel, vehicle or aircraft. Lawful visitors include invitees, licensees, contractual licensees and those exercising a right conferred by law. Section 1(2) includes those who have been invited and therefore have express permission. Section 5(1) provides that those entering pursuant to a contract are covered by the common duty of care. Licensees include those who have express or implied permission to be there. This includes situations where a license would be implied at common law. Those entering in exercising a right conferred by law is set out in Section 2(6). This includes, for example, a person entering to read the gas or electricity meter or the police with a search warrant. A license, permission to be on the land, may be implied at common law where there exists repeated trespass and no action taken by the occupier to prevent people coming onto the land. This requires an awareness of the trespass and the danger. In Lowery v. Walker, the claimant was classed as a lawful visitor when he used the defendant's field as a shortcut to get to a dairy. This was because many people had also crossed the field and the defendant did nothing to stop them, even though he knew the horse presented a danger. Repeated trespass alone is not sufficient. In Edwards v. Railway Executive, no license was implied where the railway company repaired the fence several times to try to prevent the trespassers using the railway as a shortcut. The courts are more likely to imply a license if there is something on the land which is particularly attractive and acts as an allurement to draw people onto the land. This is known as the allurement principle. For example, the berries were seen as an allurement to young children in Taylor v. Glasgow City Council. However, since the introduction of the Occupiers Liability Act 1984, the courts have been reluctant to imply a license. This was seen in Tomlinson v. Congleton, 2003, where there was repeated trespass, an allurement and insufficient steps taken to prevent trespass, yet no license was implied. The 1957 Act does not extend protection to trespassers, invitees who exceed their permission, or persons on the land exercising a public right-of-way. In McJown v. Northern Ireland, the claim failed because the claimant was neither classified as a lawful visitor nor a non-lawful visitor when exercising a public right-of-way. The same principle applies to a private right-of-way. In Holden v. White, the milkman was unable to claim when injured on a private right-of-way. Section 2(2) provides, "The common duty of care is to take such care as in all the circumstances of the case is reasonable to see that the visitor will be reasonably safe in using the premises for the purposes for which he is invited or permitted by the occupier to be there." The standard of care varies according to the circumstances. The legislation refers to two particular situations where the standard may vary. This applies to children and experts. Under Section 2(3)(a), an occupier must be prepared for children to be less careful than adults. The courts will take into account the age of the child and level of understanding a child of that age may be expected to have. In Titchener v. British Railways Board, it was held that a 15-year-old girl was expected to take care of her own safety as she would have been aware of the risks in crossing a train track. Whereas, in Taylor v. Glasgow City Council, a 7-year-old boy would not have known of the dangers of eating berries. The case of Phipps v. Rochester Corporation established the prudent parent principle. That is, occupiers may assume that young children would be accompanied by a prudent parent to supervise the child. Under Section 2(3)(b), an occupier may expect that a person in the exercise of his calling will appreciate and guard against any special risks ordinarily incidental to it. This provision applies where an occupier employs an expert to come onto the premises to undertake work. The expert can be taken to know and safeguard themselves against any dangers that arise from the premises in relation to the calling of the expert. For example, if an occupier engages an electrician, the electrician would be expected to know the dangers inherent in the work they are employed to do. In Rolls v. Nathan, the defendant was not liable as the chimney sweeps should have known of the risks of carbon monoxide poisoning. It may be possible for an occupier to discharge their duty by giving a warning of the danger. Another reason the claim failed in Rolls v. Nathan was the fact that the defendant had warned them of the dangerous level of carbon monoxide. However, Section 2(4)(a) provides that a warning given to the visitor will not be treated as absolving the occupier of liability unless in all the circumstances, it was enough to enable the visitor to be reasonably safe. The warning must cover the danger that in fact arises. In White v. Blackmore, a warning that jalopy racing was dangerous did not cover the negligent erection of the ropes. There is no duty to warn against obvious risks. This was established in Derby v. National Trust where there was no duty to warn of the dangers of drowning in a pond. According to Section 2(4)(b), an occupier is not liable for dangers created by independent contractors, if they took reasonable steps to ensure the work was properly done and the contractor was competent. Section 2(5) provides the common duty of care does not impose an obligation on occupiers in respect of risks willingly accepted by the visitor. The question of whether the risk was willingly accepted is decided by the common law principles of volenti non fit injuria. Damages may be reduced under the Law Reform, Contributory Negligence, Act 1945 where the visitor fails to take reasonable care for their own safety. Section 2(1) allows an occupier to extend, restrict, exclude or modify his duty to visitors insofar as he is free to do so. Where the occupier is a business, the ability to exclude liability is subject to the Unfair Contract Terms Act 1977. In summary, the Occupiers Liability Act 1957 imposes a duty of care on occupiers to lawful visitors. The duty is to take such care as in all the circumstances of the case is reasonable to see that the visitor will be reasonably safe. A higher standard is required where the visitor is a child, but an expert is expected to guard against risks associated with their calling. A warning may discharge a duty, but only if it is sufficient to make the visitor safe. A person who voluntarily accepts the risk may be denied compensation under the common law defense of volenti non fit injuria. Damages may be reduced under the Law Reform, Contributory Negligence, Act 1945. Liability may be excluded. If it is a business, this is subject to UCTA 1977. This video is part of a series of videos on law from www.e-lawresources.co.uk. Check out our website which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free and helps us to keep providing these videos. Thank you for watching.